The broadcast is now starting. All attendees are in listen-only mode.
Hi everyone, this is Kirsten Davis. Thank you all for joining us today. If you give me 1 second, I'm going to go ahead and turn on my recording function that just kind of disappeared off my screen when I started. So if everyone could just hang on a second. Okay, and for those of you who know how to work the question box, can you go ahead and give me a quick type in the question box to let me know that you can hear me? Oh, great. Thank you. Yes, perfect. Thank you all that you can hear me. And Julie, I know you can hear me too. I'm having trouble finding my recording button, and so I know that you're recording it too, so I think we're all set. Well, welcome everyone. I am really excited to have you all back for another installment of the series that Stetson puts on with legal writing issues and topics, and so I'm really excited today to have you all with us. That's me. I meant to show that screen earlier, but I'm going to be both your organizer and participate a little bit today in the session with our guest, Sarah Ricks. So as I mentioned before, usually I have you test your Q&A box, but I did that earlier. If you're not familiar with our system, and this is your first time using it, you have a little questions box over there on your control panel. And the control panel, then you can type in that box right there when you have questions for us. So we will take some time between our sessions to answer your questions. So as Sarah's talking or I'm talking, feel free to type the questions in that box, and we will answer them during the Q&A session. And also, if you've never attended one of these before, I just want to make sure that you kind of know what you're looking at. The GoToWebinar interface, which is really handy, has a viewer window on the left where you can see what's going on, and then you probably see this funky thing on the right that you've never seen before, which is a control panel. And for you, there's not a whole lot there you need to worry about other than perhaps the questions box that I mentioned, and then that little caret there lets you move that control panel out of the way. So if you just want to scoot it out of the way off the screen, you can do that, and it will close right up like this. And then you just hit it again, and you can open it right back up. If you're having any trouble with your audio, that audio setup is where you can go in to deal with your sound or volume. And then again, as I mentioned, the questions box where you can enter your questions. If you get tired of the control panel opening and closing on its own, under the View menu in the top ribbon, you'll find that little check-marked Auto Hide the Control Panel. If you want it to stay on the whole time, just uncheck that and it will stay on the whole time. Otherwise, every so often it'll close up. Okay, just as a reminder, all the webinars we've done are now available for replay on our legal writing website. There's no need to register, no need to log in, and the address is right there on the screen for you. Feel free to share that information with your friends or with others who you think will benefit, and we have the whole series on there, and this one will appear there today as well. Okay, so there are two of us today presenting on this topic of designing problems, and Sarah Ricks was so kind to join me. Just let me tell you a little bit about Sarah for those who don't know her. Sarah is a clinical professor at Rutgers-Camden. She graduated from Yale Law School and then clerked on the for the Eastern District of Pennsylvania Federal District Court. And she was an appellate and legislative attorney for the City of Philadelphia Law Department for many years. Was a state and federal appellate litigator. At Rutgers, she teaches legal writing, current issues in civil rights litigation, public interest research and writing, and advanced legal writing. She's a the advisor for their Journal of Law and Public Policy, and she also co-directs the Pro Bono Research Project, which I think is a fantastic idea that offers free student legal research to public interest lawyers. Sarah, thank you for being with us. And of course, you all know me. I direct the research and writing program here at Stetson, and my most current adventure is working on our new Institute for Advancement of Legal Communication, and you see our new logo there at the top, which I'm really excited about. Okay, and so what I'm going to do now, Sarah, can you hear me?
I can.
Okay, Sarah, I'm going to turn it over to you. Sarah's going to talk a little bit about designing appellate brief problems and about problem design in general. So Sarah, I'm going to release the screen over to you right now. Okay, Sarah, we can see your screen.
Great. Everybody has the Designing Appellate Brief Problems up on the screen. Good afternoon. Do you all see that? I hope so.
Yes, Sarah, sorry. You had it, so great.
Okay. I'm happy to take questions during the presentation. I think you can do those by typing them in. And of course, we'll also have time for questions at the end. So I was so pleased to be asked to do this today because designing appellate brief problems is actually one of the things that I think is most fun about my job. It's a really fun job in many respects, but this is one of the things that I enjoy the most. It's a great deal of fun. It is also a huge sponge for time. So when I design an appellate brief problem, and I have designed quite a lot, one of the things that I have learned is the most important thing is you must love the topic. You have to spend a lot of time designing the problem, a lot of time thinking about the cases, answering questions about the structure from the students, answering questions about the analysis, lots of time reading multiple drafts of many briefs. So you need to choose a topic that's really going to sustain your interest all the way from researching those issues to drafting the factual record, which to me is kind of like writing a novel, to grading the 26th or 42nd version of the same brief. So choose a topic that you love. I think there are lots of great places to find topics for brief problems. You could choose a topic, and this is typically what I do, is choose a topic that I'm researching for my own scholarship, something that I really want to explore and learn in depth, because you do learn it really in depth when you teach a semester-long brief problem or even half a semester-long brief problem. So you could explore a topic that you already wanted to look into, or a topic that you see addressed in a secondary source, a law review, an ALR article. You can look for ideas in general news sources, the newspaper, legal news sources, or if you're particularly looking for appellate briefs, legal blogs like How Appealing or the SCOTUS blog. If you're particularly interested in issues involving, say, circuit splits, you can look at cert petitions to the U.S. Supreme Court or the similar petitions to the state Supreme Court in a state you're interested in. There are also wonderful brief banks on Westlaw and Lexis. You can look through appellate briefs in the brief banks and find out about current issues in areas of law that you think would be fruitful sources for brief problems. Whatever the source you choose, I think the trickiest thing is pitching a brief problem at a level that's sufficiently complex for the students to take several weeks, 7 weeks, 8 weeks, 9 weeks to unravel, but not so complex that it's too hard for one else. Because, of course, the primary purpose of this is as a teaching tool for the one else to learn research skills and writing skills. So let me turn to where I think is also a good starting point, which is in thinking about topics for brief problems, I think it's very useful to start by defining what your own teaching goals are, defining what skills do I want my students to learn from this brief problem. So this is a sample list of skills that you might hope to teach via an appellate brief problem. For example, how to synthesize legal rules from multiple authorities. I think that's likely a goal for most of us. Appreciation of hierarchy of legal authority, of course made complex with non-precedential opinions. How to state a legal rule and then prove it. How to apply a legal rule to a new but different set of facts. Identifying and refuting plausible counterarguments. Pulling relevant facts from a realistic record of, say, depositions, police reports, medical records, organizing a brief that addresses more than one legal issue, and how to research with secondary sources and other types of legal sources. And you probably want to teach all those skills and likely many more, plus design a brief problem that will give the students a rich oral argument experience. Now, an oral argument experience that differs from student to student, I think, is one way to keep the brief problem fun even all the way through the oral argument, and keep it fun for the moot court judges. Many of us invite outside judges to come in and moot cases with us, and it's fun to keep it lively and different with each argument. So let me unpack some of those likely teaching goals, starting with synthesis. It's challenging. We all know this. It's challenging for one else to synthesize legal rules from multiple authorities. So it's kind of challenging for me to find a visual image that captured that idea too, but I kind of like the braiding idea. So there are advantages and disadvantages to designing brief problems based on different sources of law. One of the advantages of using state common law is sometimes state common law tests have some sort of tidy 3-part test, 4-part test, and it can help the one else to start with a rule. And a lot of those rules have a certain amount of ambiguity built right into the rule, like what conduct is reasonable, or how the cases flesh out the meaning of material. So if one else have already been exposed to torts and contracts, you can build on that familiarity when they're learning this new law that they need for a state common law brief problem. So those are all some advantages. Some advantages to basing a brief problem on a statute. Again, it starts with a rule, and that's a helpful beginning point for the 1Ls. Often, again, in the rule, there's some ambiguity, and that has to be fleshed out by the cases, like what is a profession under the statute, something my students are grappling with now, or who qualifies as a parent or a child under the statute. One thing that's a real advantage to using a statute for a brief problem is 1Ls might not otherwise be exposed to statutes in any in-depth way during their first year of law school, and yet, of course, they're going to be exposed to statutes in their job. So that can be a real plus for their own legal education. Now, brief problems based on constitutional law can be a lot of fun. That's what I tend to do. There are some disadvantages. Now, some students lack familiarity with constitutional law at the time you need them to have it. Say your semester begins in January, the same time as their constitutional law classes do. Even if they will cover this particular topic in constitutional law, they might not have reached it yet, or very often they won't reach it at all because not all constitutional law classes are, obviously they're going to be limited, and they tend to do a lot of separation of powers issues, but they may not do quite as many individual rights and liberties issues, and that's what I tend to do brief problems on. Another disadvantage is that the decisions from the federal appellate courts tend to be complex and lengthy. Now, I also consider that their greatest advantage. In other words, brief problems based on constitutional law, I think, are fun in part because those complex, lengthy decisions let the students explore interesting issues. There's lots of ambiguity. There's lots of room for creative arguments. So an approach that a lot of people take is to teach a progression of problems over the course of the year. So maybe begin with a state common law issue with elements, progress to a more challenging statutory analysis, and then save that complex constitutional law issue for the semester where you can really delve into it for the whole semester in teaching advocacy. I like those federal constitutional law or Section 1983 brief problems because there's so many opportunities with them. And I'm not saying it's limited to this area of law, but these are the ones that I've explored the most. For example, I've created brief problems that require students to reconcile tension between the binding Supreme Court law and the binding circuit court law that arguably is inconsistent with the Supreme Court law, and yet they're both binding. Very practical, realistic experience for litigators to learn about. Similarly, I've created brief problems where there's tension between binding circuit opinions. The opinions are all binding and yet very difficult to reconcile. Again, a very useful and practical experience for 1Ls. I've also created brief problems where the relevant circuit, say the Third Circuit, relies a great deal on the law of other circuits in this particular arena. So a wonderful opportunity for students to rely on persuasive authority even when there isn't a circuit split. Obviously a circuit split they would rely on persuasive authority, but even when there isn't a circuit split, if you have a particular legal issue where the circuits tend to turn to one another because no one circuit has a great deal of law, that gives the students the opportunity to build arguments based on persuasive authority applying a similar rule in similar factual circumstances. Another opportunity with the constitutional law, Section 1983 brief problems, is if there's a totality of the circumstances test, like what's action under color of law, you can create a factual record that really pulls the students in different directions. And again, that creates opportunities for fun and very lively oral arguments, as well as arguments on both sides in the briefs themselves. I just want to pause there for a second to see if there are any questions so far. I'm not sure how I would know there's questions.
I would tell you, Sarah.
You would tell me.
I would tell you.
All right.
There aren't any coming in yet. So.
Okay. All right. We'll have to take
what I've heard so far is doing great, very thorough. That's what I've seen so far.
Okay.
Okay.
So let me turn to another one of the teaching goals that we likely all share in designing brief problems, and that is hierarchy of legal authority. So this is a core concept that students learn by analyzing brief problems and probably memo problems too. I think this is especially important for legal writing faculty because students are not really exposed to hierarchy of legal authority in any other 1L class. So you may want to, in your brief problem, expose students to both binding and persuasive authority so they really grapple with and experience the difference between binding and persuasive and explore the complexities of hierarchy of legal authority. If you're concerned, for example, that the problem you're designing could lead to too many sources of authority for 1Ls to be able to effectively synthesize, here's a couple fixes that I've found to be helpful in the past. You can consider imposing limits on the authority that 1Ls can use. For example, you could limit 1Ls to just recent cases, say since 2005. Or you could limit 1Ls to just binding cases. Tell them we're only going to rely on Sixth Circuit opinions. Don't look at authorities from the district courts within the Sixth Circuit. Don't rely on authorities from other circuits. Or if you're in one circuit and at this point most of the federal circuits produce about 80% non-precedential opinions and you're worried perhaps that there's too many non-precedential opinions, you could say to your 1Ls, okay, just rely on the precedential opinions from the relevant appellate court and don't use the non-precedential ones from our appellate court. All different ways you could limit the authority if you're worried about overwhelming the students. So a key purpose I think all of us share, again, for brief problems is we want it to be a good vehicle for students to learn how to apply a legal rule to a different set of facts. And in considering topics and in designing brief problems, as you're doing the research, you're probably considering, well, what factual analogies are my students likely to draw? What analogies will the students likely draw between the facts of these cases I'm reading, the decided cases, and the facts that I want to have them analyze? What I try to do, and I think this is useful, is to design a fact pattern that's not directly controlled by a single case or a single line of cases, but rather something that falls between the cases, so that students have to analogize and have to sort of abstract the facts one level, generalize one level, so they have to recategorize the facts in some way in order to draw parallels between the client's facts and the facts in the decided cases, or else have to really delve into not simply the holding of a case, but the reasoning from the decided cases in order to effectively analyze the client's facts, the pending facts. I think that's more challenging. I think it's a richer experience for the 1Ls, but I also think it's more realistic and therefore results in probably better writing samples for the students to use in their job searches, which is, of course, paramount in all of my students' minds. Brief problems are usually balanced, and hence the seesaw that's balanced. Brief problems are usually balanced, meaning there's plausible, decent arguments on both sides, and really no clear answer. Again, I think this is a teaching priority for most of us. It helps students to identify and refute counter-arguments, plausible, alternate ways to look at the facts. And the different outcomes depend on how the student is reading the rules or how the student is understanding the important facts in the decided cases. I think this is one of the most effective ways for us to teach our students a greater tolerance for ambiguity. So I think this is one of the most important teaching goals in my 1L year. So because identifying counter-arguments is one of my main teaching goals, I actually design all my problems to be balanced, even all my memo problems. So there are good arguments on both sides, and I like to see the whole class split on their predictions. I think it's fun for students. I think students have the challenge and fun of drafting creative arguments. But again, oral arguments are more fun in the brief problems when they're very different from one another. And so when there's a lot of different strains in the law, different emphases in the different briefs, in the different oral arguments, it makes the oral arguments just that much more lively and a lot of fun for me and for the visiting judges. So that's passing the baton there, that picture. Creating brief problems, when I started out, I said it's very rewarding, but I want to be honest, it's very time-consuming. I have spent months creating certain brief problems. Once I create them, I use them again and again. I change them. The new law comes out, and so I change them. I tinker with facts. But when I create a new brief problem, it easily can gobble a good chunk of my summer. I have one brief problem that I haven't been able to run yet because the Sixth Circuit, the law just has been too much in flux. So it's very time-consuming, much as I enjoy it. But I wanted to deliver the good news that you already know how supportive the legal writing community is. And the good news is that colleagues are very willing to share brief problems. So you can borrow brief problems from the LWI Idea Bank. And often there are other supporting materials included in the Idea Bank, good sample briefs, for example, or solid teaching materials, exercises you can use. I always submit lots of supporting materials when I submit something to the Idea Bank. I should just add one quick caveat, which is I do have two different brief problems in the Idea Bank, and one of them is a two-issue problem where one of the issues became moot. I'll just add this quick addendum. The issue became moot after Wake Forest borrowed that brief problem and invited Justice Roberts to judged. It was their moot court competition, and Justice Roberts, I guess, didn't like this wacky doctrine that I based the procedural issue on, and the following year the Supreme Court granted cert and obliterated that doctrine. So one of my brief problems that's in the Idea Bank has 2 issues, and only one is a salient issue. The other one was mooted by the Supreme Court. So if you look on the very last page here, there's a bunch of helpful articles, short articles that, this is just a selected list. It's not comprehensive by any means, but this is a list of articles that can help you in designing brief problems, and some of them also apply to memos. But they're all very useful, and I've certainly used a lot of these. So I'm happy to take any questions now or when Kirsten says. I'm open to whatever works best for you guys.
Okay, great, Sarah. Well, we do have a couple questions, and we'll leave that
Sure.
slide up for a minute if people want to take notes on the materials that you have posted there for them. So we'll just leave that slide up. So I have one question here that says, you might have mentioned as you were talking that perhaps if students haven't had con law, maybe the question, maybe a con law question is not as good and good for them. And the individual here asks, do you think that's true of any first-year legal research and writing problems? Should they be limited to topics that the students have been taught or may be familiar with?
No, I don't think so at all. I don't think they should be limited at all. I was just saying that it's possible that they might feel somewhat unfamiliar with constitutional issues because you might start the problem in January and say they aren't going to reach that issue at all. But I'll give you an example from my own experience. I teach the last 5 or 6 years, I think, I've taught an Eighth Amendment problem, a constitutional problem based on the Eighth Amendment. And that is not a constitutional law topic that most constitutional law classes ever cover. And I don't think that's an obstacle at all because I teach it. And the students often come to me and tell me that they feel like they understand the Eighth Amendment issue better than they understand other constitutional law issues because what other issue did they get to spend 9 weeks analyzing? Mm-hmm. So no, I don't think it's an obstacle at all. I flag it as a potential disadvantage, but to me it's one that's easily surmountable. If you think about even the when you teach a subject that students might have had some exposure to, say in the fall semester I might teach a negligent infliction of emotional distress because it has a nice tidy 4-part test. I'm teaching a particular jurisdiction, say Wyoming. Even if the students have heard that tort mentioned, and many torts classes wouldn't even cover that, they're not learning the nuance of the particular tort that I'm teaching them. So even if they've had exposure to the idea of what a tort is, they aren't learning in depth. They aren't learning it in the same in-depth way. They have to learn it in order to analyze it for me. So no, that's for the same reason I don't think exposing them to new areas of law is too confusing. It might be confusing to expose them to wholly new sources of law, possibly, for example, federal regulations or something like that. But as long as you're willing to teach it to them in class, then no, I think you could probably do just any topic, really.
I think sometimes, too, just to kind of add on to that, it's nice to do something that cuts across various topics. So in the context of fraud and duress, I've done sort of marriage problems that use those concepts but go back to a statute, for example, and don't really involve maybe the contracts area that they learned it in or the torts area in particular that they learned it in, but they're familiar with the concepts. And that also kind of keeps me out of trouble with respect to something they may have learned in a particular way in a particular class, but I get to address topics that they have some familiarity with. Another question you have here, Anne asks, how much background do you give students and how do you give it when you teach a problem with which the students are unfamiliar? I've run into this with Section 1983 actions and search and seizure problems.
Mm-hmm. I give them a fair amount of background. So, for example, I will I will give them, say, 4 cases to begin with, if it's a brief problem. I'll have, say, the 3 or 4 cases that are cited in the district court opinion. I'll tell the students, go read those cases. Then I will give them questions to guide their reading, maybe 7 or 8 questions for each case. Then I send them to the front of the room, and they have to answer those very detailed questions about the cases. So inadvertent, or not, sort of obliquely, I'm teaching them a little bit about oral argument and standing up in front of the room, but I'm teaching them the law. And I've highlighted for them with the questions to guide their reading what issues I think they really need to focus on in reading the cases, in reading those early cases. Then they're free to go off and research and locate other cases. I also teach them the law by showing them how you might create a case chart, identifying if it's a complex legal test, like in the 8th Amendment, it's like a 6-part legal test. I'll put that up on the board. So I do a lot of that. I do a lot of teaching the problem in class, in part because I think it helps them, in part because I think it helps them write better briefs. And I also think that getting them to talk about the law fairly regularly is all to the good in sort of teaching them oral argument skills. So I do a lot of background. And frankly, I learned that the hard way, because the first time I taught a Section 1983 problem, I didn't do that, and they didn't understand it in the way that I thought they needed to in order to write effective briefs that would be good writing samples.
I think that's right, and we've done a little bit of that here too. Sometimes I will attach secondary sources to the materials that they have, or I will point them toward particular secondary sources as a place to start, and then sometimes we'll have just review classes along the way, kind of asking students what they've been finding, and even kind of just sort of starting a preliminary outline on the board, particularly if the topic is complex. And I found that that really has no negative effect on their learning or even sorting themselves out in the end, and if you're concerned about grading, for example, but it does end up, I think, being a teachable moment for them rather than kind of a moment where they're lost and don't really have a sense about how to start. And then a few of us also do sometimes when the research trail comes in, if we've assigned that, then we might go over sort of what we think the key cases are, eliciting that from the students. And then, that enables them to kind of see that there's a particular body of cases, and if some students haven't run into those yet, that can be helpful to them in kind of getting back on track, particularly because the research trail is designed to do that for them anyway. So that's something that I know I do and some of my colleagues here do. And there are a couple questions too about appellate briefs and trial briefs that you have entered, so thank you for that. I'm going to talk a little bit about trial briefs. Sarah does mostly all appellate brief design, right, Sarah?
Yes.
And so I will kind of hold those questions back till I talk just a few minutes, and so I'm going to take the screen back from you, Sarah, and thank you.
Okay.
Okay, so hopefully everyone can see my screen. If you can't, just let me know. Julie, I can't see my controls right now, so if there's something wrong, just chime right in. So I wanted to talk a little bit about trial memoranda. I've had the benefit of teaching in 2 different programs, one where we only did trial memoranda for our second semester persuasive writing course, and then here what we do at Stetson, which is have a trial memorandum that leads up to an appellate brief. And so I've been able to kind of look at both of those, and because Sarah does mainly appellate brief design, I thought I would kind of fill in maybe some of the gaps around that with talking about the trial memorandum. A couple things I think that are important about trial memos is that they can either be a stepping stone assignment or the ultimate assignment depending on their complexity. As you know, you have simpler, maybe discovery motions, for example, leading all the way up to something as complex as a summary judgment motion and the summary judgment motion standard that students have to deal with. You can make them connected to the appellate brief or not, and we've done different things here at Stetson. Sometimes we've connected them, sometimes we haven't. I think there are some real pros of the trial memorandum being appealed in your class as your final assignment. First, the students already know the doctrine and they can get a real sense of how a case progresses from the trial level to the appellate level. And a colleague of mine pointed out that it also gives you the chance to have the students flip sides in oral argument. So if you do a smaller oral argument on your trial memo and then maybe the more formal or more sophisticated oral argument on appeal, you can force the students to argue opposite sides of the issue, and you can also add in an additional issue to make the appellate brief more complex than perhaps the trial brief was. The cons, I think, of being connected is if you really don't like the doctrine, it can get boring for the students or frustrating, and one of the things then that makes that work well is adding in a second issue on appeal that is rationally related to the first issue but perhaps wasn't briefed or worked on before. The other thing is I tend to not grade my earlier assignments. Rather, they're good faith efforts and an opportunity for feedback. And so if you connect the trial memorandum to the appellate brief, it makes it hard to reuse that trial memorandum as a teaching tool from year to year, because sort of once I learn the material, then I can become more efficient at teaching that and teaching the underlying skill set that I hope that they have, and so that ends up requiring me to invent two different kinds of writing problems rather than one. And the other thing that can be a problem is the standard of review on appeal. The problem you may pick for a trial memo may not have a standard of review on appeal that is an easy one for students to apply, or maybe too much of a challenge for them or confusing, and that can be limiting if they're connected. One of the things I really like about trial memos is their flexibility. As I mentioned, you have discovery motions, like motions to compel or for protective order. In the criminal context, if that's an area you like, you have motions to suppress as a pretrial motion. In trial, of course, you have your 12b6 motion to dismiss and motions for summary judgment, which students, I think, as lawyers will most likely encounter in their career. I've even done preliminary injunction motions, which have a sort of great multi-part element test that can be used by students, and even post-trial motions, like motions for judgment notwithstanding the verdict or for new trial, can be used. So you have a lot of choices there about the kind of content you want to cover, the level of difficulty. And so, for example, you could start with a motion for a protective order, which may be much more straightforward and a little bit shorter and easier to address, and then build to a more difficult, complex summary judgment question. And that you might even be able to have a small oral practice argument on that smaller motion. I think they're also a different experience than an appellate brief for students. One thing I think it really does is get them working with the rules of civil procedure, a class that they likely will have had or will be taking when you're assigning a persuasive writing problem. And I think that makes them look at those rules in a different way than they would have had they just learned them in class, in their civil procedure class sometimes, where they might not have the opportunity to work with them. And then it also makes them work with, of course, just like appellate standards of review, a fairly difficult, in the case of a summary judgment standard, for example, a fairly difficult lens for reviewing the materials that they have in front of them, and they really have to master that. And also you can have them think about what the appellate review would look like as well, in thinking about how an appellate judge would review the ultimate decision the judge has, so you don't have to exclude some discussion or talk about appellate standards of review. The students just may not be applying them with respect to a trial brief. And the second point there that I meant to mention is I think sometimes they're less formally complex. So the appellate briefs tend to have lots of parts, the standard of review section, the jurisdiction section, the summary of argument, and then students tend to get stressed about the table of contents, table of authorities, and I think sometimes that has them get their eye off the ball a little bit with respect to working on maybe other important learning goals. And so the trial memo can be really helpful in that regard, because it can be limited to an introduction argument, and conclusion, and really let students build those skills where they're not focused so much on the larger structural pieces. You can also think about whether you want them to draft a motion, the memorandum in support of the motion, or both. That gives them a little bit different experience if they actually draft the motion, since so many of them will draft motions even if they're just just heard orally. Or you can do the motions yourself to force the issues and define the issues for the students in a way that makes those a little bit simpler. And I'll be interested to hear Sarah's view on sort of record design for appellate records. What I find is when I sit down to design an appellate record, that's far more daunting for me than thinking about how I might put together, for example, a 12b6 motion, which is basically your complaint, or if you were to do affidavits and some deposition excerpts for your summary judgment motion. And so I tend to probably have a less incomplete record when I'm doing a trial memorandum than I do simply just by virtue of efficiency and survival when I have an appellate brief one as well. And so a couple other things to think about is Sarah was talking a little bit about limiting the research. I think sometimes trial memoranda allow you to have some logical limits to the research if you think the question is too big, and you can talk about hierarchy of authority there too. So you can limit it to maybe your sister trial courts and the appellate level above them and the Supreme Court of the jurisdiction, and talk about how likely it will be that the trial court will be interested in mostly the appellate cases from its controlling court. So it does provide you with some logical limits if you want to apply them. And then for oral argument, and I think this is something you may not think about a lot, but if you do an oral argument on an early trial memorandum, you can do it informally. So you can sort of think about doing it as if you were coming into the judge's chambers and making these arguments perhaps in the judge's chambers at the conference table, which happens in a lot of jurisdictions on trial memoranda. And so students could have that experience along with, if you teach a second either appellate brief or something more complex, a more formal oral argument. Just a couple thoughts on the summary judgment motion problem, which I think is a good choice for an ultimate assignment for trial memos. The question I think that's always bothered me the most when I'm trying to design a summary judgment motion problem is whether I should have an issue of law, an issue of fact, or both. And I think one easy way to approach this is, of course, to give them no genuine issue of material fact and tell them that so that they can argue the law. But you need to decide that ahead, however, and try to make sure that you have done a good job of giving them undisputed facts. Otherwise, I find that actually the word count or the length of time that they'll spend on a fact argument is pretty significant in a summary judgment motion. And then I think one of the problems is, if your program is like mine, students don't have the chance to write a response or a motion and then a response. And so if the movement is going to argue, well, if the respondent, I should say, the person who would be writing the response, if the respondent thinks that there's an issue of fact, the movement, of course, isn't going to argue that up front. They're going to argue just the opposite, or perhaps even not pay attention to that question. And so I think it's kind of difficult for both sides to sort of anticipate what the other side is going to do, and that one would only be inclined to write that issue of fact into the problem. And so it can end up with different length memos, or having your students allocate space kind of in a way that you didn't anticipate. And so one of the things that I found is, if I make it only an issue of law with no disputes of material fact, that the students can write cross motions. And so, both of them having made a motion that they're entitled to judgment as a matter of law, and then they're sort of both in the initial memorandum position, and it makes things, I think, a little simpler for 1Ls. Now, it might not be something you'd want to do with advanced students, but at the 1L level, I think it simplifies things a little bit. And then I have to thank Ruth Ann Robbins for making me think about this a little more carefully. And that is, if you want to teach factual persuasion or some of the storytelling techniques as you're creating the record, and I think this is true for both appellate and trial memo or brief writing, is that you have to think about what kinds of facts you have in there to argue from sort of the emotional or the character, competence, goodwill perspective, the pathos and ethos perspective, and sort of reflect on what students may need to create characters or to frame the situations a particular way or to advance a particular theme or adopt a particular tone. And it's very easy, I think, to write records that lend themselves only to that rational argument rather than pathos and ethos, and so it's something that I try to think about. And then finally, and we'll turn it over for your questions, I've always struggled with what to do about local rules, and Sarah, maybe you can talk about this from the appellate brief perspective as well. You can always assign students, real local rules of the local jurisdiction, but they don't really fit very well lots of times, or I find myself giving students a detailed list of which ones apply and which ones don't, and so I tend to write my own local rules. This limits the complexity but allows them to get used to following the local rules, and some of the things that I include on that are format and length, citation, what the required parts of the document will be, particularly if it's something special that I'm doing because I really want them to do an issue presented, and I want a section on that, and I even give examples of some of the more routine parts, maybe the case caption or the signature block or the certificate of service, and that seems to really provide good scaffolding for students. I put the submission requirements in, if we have any limits on collaboration, if I'm limiting the research or the issues, and then I often have them put in an integrity certification at the end of the document that just says they haven't cheated or unfairly collaborated, and so I tend to limit my documents that way. So we'll go ahead and take some more of your questions. You probably saw my screen change. I apologize for that because I lost my control panel. And so, but I can see the control panel now. You just, this isn't the best view in the world, and I'll fix that in a minute. But I wanted to be sure I could see the questions. And I see one, let me see. Oh my, I have to scroll back through. Hang on just a second. So Sarah, do you have any thoughts or responses on the things I was talking about?
Well, yeah, while you're doing that, so one of the issues that Kirsten talked about just now, which is a really helpful presentation, one of the things she talked about was the storytelling aspect and creating some empathy for your client. So, for example, in the context of doing an Eighth Amendment brief problem, I have two different people who are the central characters: a prisoner who may be unsympathetic because he's a prisoner, and a guard, but the prisoner is a model prisoner and is trying to leave his gang and is trying to turn his life around and is becoming a counselor for other people, so that makes him actually quite sympathetic. And then the guard is accused of being, sort of lazy, indifferent, and not focusing on how he could help the prisoner, and that results in the violence against the prisoner by his ex-gang members who are retaliating, which sadly is a very common situation. There's lots and lots of law on it. And but again, I don't want the guard to be too unsympathetic, so we create something that will sort of get his lawyers rooting for him. We have him be a dedicated neighborhood volunteer. He's working with young boys to mentor them and keep them away from a life of crime. So we plant a lot of facts like that as fodder for the students to include in their briefs. None of them particularly legally significant, but I think actually have a great deal of emotional resonance and help them to identify with their clients and try to get the court rooting for them. So there's a lot of, I think the students have a lot of fun with those facts.
Great, and someone else out there had actually asked the question of the kinds of facts that you like to include and gave a hat tip to Ruth Ann for reminding us all to do that. Another question came in, what about closing the universe of cases after students' research is assessed, even for a final brief? And the note that, sometimes maybe that gives a little bit more even playing field or makes it a little bit easier for you to assess their work. My thought is twofold. If you're grading research at the level of did they find key cases, then of course you don't want to kind of close up the universe or talk about what cases they found. I always tell students if I choose to do that, that if there are other things they want to cite, of course they can, and students are often very clever about citing other types of things, and I can evaluate sort of at least their thoughtfulness about the research that they want to do or the cases to conclude their authority selection. But I have often done this in the past where I do not fully close up. I think we've called it partially closing the universe, where we identify the core cases that should be cited in the brief or are really central. How about you, Sarah? Do you ever do that where you kind of give them some guidance in that respect?
For the spring brief problem, no, I don't close the universe. I actually don't close the universe in the fall either. I don't close the universe in the spring in part because there's such a rich variety of cases they could choose from. I think it gives the students who are truly motivated and really want to shine, it gives them the tools to do that. Also, the cases that they choose will affect the legal arguments that they make, and I think that one of the challenging things in legal practice is you're trying to anticipate what the other side might say. As Kirsten was pointing out, in many programs and at Rutgers, we have simultaneous filing. So the plaintiff appellant side never has an opportunity to respond to the brief filed by the other side as they would in real life. So another function of not closing the universe is over spring break, I have my students exchange their briefs, of their oral argument opponent's brief, and now they get a chance to read the arguments made by the person who they are going to argue against. Well, there may be cases in there that they've never seen, or there may be cases in there that they rejected. And so their homework over spring break is read your opponent's brief, familiarize yourself with the arguments you're going to face at oral argument, and if there are cases in there that you haven't seen before, go read them. And figure out what you're going to say at oral argument, because you probably will face questions at oral argument about those cases. And to substitute for the real-life experience of getting an opportunity to file a responsive brief, I have my students draft oral argument questions for the other side, for their particular oral argument opponent. And then I try to use that at the oral argument. So it's kind of in lieu of a responsive brief, but it's also my method for making, it's how I try to get them to become ready for oral argument too, by really grappling with the arguments in the other side's brief, which in my own practice as an appellate lawyer, that was the first thing I did to get ready for oral argument, was read my opponent's brief. And just on the issue of facts, let me just add this. For 7 years, almost all I did was write appellate briefs. I was a trial lawyer before that. But for 7 years, I just wrote appellate briefs. And I started out thinking it was all about the law. But after about a year, I realized, no, this is all about the facts. Appellate brief writing is very much about the facts. So I arrived at Rutgers with the idea that it was going to be really fun to teach students how to write the facts, because that's really where your persuasive writing can really come through, as long as it's subtle.
Sarah, yeah. No, that's great. Here's another question, and it goes to the timing of oral argument. So do you always have your oral argument at the end of the session, or at the end of the semester after the briefs come in, or do you ever time it differently?
My attempt is always to make it as realistic as possible. So I sit on the panels that judge the oral arguments, but I also ask the students about their career aspirations, if they want to be prosecutors, if they want to be environmental lawyers, etc. I invite local lawyers who practice in the arenas that some of my students want to pursue, And I see the oral argument opportunity as both to learn about oral argument, but also an opportunity to make a good impression on a lawyer in the area that the student wants to pursue. So I tell those students in advance, I will be giving your briefs to the oral argument judges. These will be judges. They're not judges. They are lawyers. These will be lawyers who you probably want to make a good impression on. So always the arguments have to be probably about 2 or 3 weeks after the students have turned in the briefs. And that's because my outside judges are real lawyers. I want them to have read the brief, and I want the students to understand that in the real world, you are not only going to be asked about your own brief, you're going to be asked about your oral argument opponent's brief. Your opponent relied on Smith. You didn't. Distinguish that case. Your opponent argues X. How do you respond? I want them to have that really rigorous oral argument experience because that's what oral argument's really like. So, yeah, I always have them do oral arguments after the brief is turned in. However, as an experience during the process of writing the briefs, I have them do 90-second oral arguments in class at least twice. So they get the experience of responding to one very tough question, but they get to brainstorm with a friend before they have to go up in front of the class. Those are very lively and very fun and not nearly as sophisticated as the actual oral arguments, which are frankly very similar to real Third Circuit oral arguments.
This is a question that I've struggled with as well, and for me, I've done it both ways, where I've done it at the end after the briefs have come in and we've had outside evaluators in the way that you're talking about. And then I've also been in the circumstance where we haven't done it that way with judges and lawyers coming in. And in those circumstances, I've sometimes tried it where I have had the students exchange drafts of their briefs, just like you were describing, Sarah. But then we would have the oral argument, and then the students would have another week after that to turn in their brief after having the oral argument experience. And I think you're absolutely right that it is not a real-world experience to not have it at the end. Yes, but for me, I found that students tend to think through the issues differently after they've had a chance to have that exchange with their professor or whoever the panelists are. And for me, it's been, I think, fairly productive on the times that I've done it, and the students have given me good feedback. And I think I struggle with exactly what you're describing, which is the, having that experience of going through the steps as they would in practice and having the chance to maybe have that interaction and then jump back into writing it. But I've tried it both ways. And
I agree with you. That's very valuable. I mean, it's a different approach. I try to have the best of both worlds by integrating multiple short oral argument experiences throughout the semester while they're writing the brief. So, for example, I'll bring 4 students into my office, 2 representing either side, and have them do sort of a quasi-adversarial conference. What fact are you most afraid of? Turn to the other side. How are you going to exploit that fact? Turn to the other side, first side. How are you going to anticipate and refute any arguments based on why that fact is bad? How are you going to reconcile that? And so I think that helps them really deepen their arguments and work them out during the semester. But yeah, no, it's a different approach to have them do the full 15-minute oral argument before or after. What I especially like, though, and I guess you thought of a way to do this, is to have the students have to be able to respond to questions based on their opponent's brief. But yeah, no, some of my colleagues, Ruth Ann, for example, has oral arguments before the brief is due. At least one other of my colleagues does it that way. And it's a different approach. So. No, I think it's interesting, and I probably tinker with my semester every year.
Great. Well, we have one last question for you, Sarah. Someone asks about, for a constitutional law question like an Eighth Amendment question, how many pages would your would students typically write? And I'm assuming that's sort of meaning of the actual argument section itself. How big are those assignments?
I think I don't limit the full brief, so the brief can be as long as you want, but the argument section I do limit strictly to, I can't remember, 11 pages or 12. Obviously, you could go on for 45 or 50 if you really wanted to, but you know, I'm not going to read all that. So, yeah, they can do a really good, coherent oral argument succinctly in about 11 or 12 pages. But the fact sections, you know, those might go on for 5, 6 pages. I mean, they really do appreciate the nuance and complexity of a rich factual record. And depending upon what cases they've found, which is the other reason I don't like them to know what cases their opponents are relying on, depending on what cases they've found, I've planted different things in the facts that could become more significant or not, depending on whether students are going to rely on particular cases or not.
Well, great, Sarah. Thank you so much, and thank you everyone for all of their questions. We are wrapping up here, and please, on your way out, you should receive a quick survey, just 2 questions that asks you a very important question about what other topics we should be covering. So on your way out today, please do give us your feedback and let us know what other topics you would like to see covered here. And thank you to Sarah Ricks for joining us today. That was wonderful information, Sarah, and extremely useful. And so from Stetson, thank you all, and have a great rest of your day and a good end of your semester. Bye-bye.
Thank you, guys. Thanks. Bye-bye.
Bye.